forensic medicine. The first question says define inquest. What is a inquest? So let's discuss what is a inquest. Define inquest. So how will you define an inquest? What are the types? What is the police inquest and what is the magistrate inquest? These are the important, and this can come as a long answer question. Okay, so let's begin. So legal procedure chapter. In this chapter we have definitions, we have courts in India and magistrates, procedure of trials in courts, offences in courts, uh, pre-jury, hostile witness, court strictures, dying declaration, dying deposition, latest notifications and medical certificates and reports. The most important long answer is about the inquest. Then short answers we have court of law, evidence, dying declaration, summons, subpoena, cognizable, non-cognizable offences, about witness, okay, forensic medicine definition, perjury, conduct, money, leading questions, okay, dying deposition, cross-examination, re-examination, okay. We have multiple choice questions also at the end. Okay, so let's begin. Let's define inquest. What is a inquest? So an inquest is a inquiry into the cause of death. Inquiry or investigation into the cause of death. So inquest is a inquiry into the cause of death. When we inquire when the death is suspicious, when the death is suspicious, or when the death is unnatural or sudden. When the death is unnatural or sudden, then we define, then we do inquest. Okay. I'll be connecting microphone now. I was connecting the microphone. 1 minute. Okay, let's start.
One second. Let me check whether I am clearly audible or not. Okay, let me just once confirm. Let me just confirm whether I'm clearly audible or not. Just a minute. Just a minute, let me confirm whether I'm audible properly or not. Okay, just a minute. Just a minute. I'm just trying to locate my device. Okay, fine. So if I'm clearly audible, please give me a thumbs up. If I'm clearly audible, give me a thumbs up. Just a thumbs up. If I'm clearly audible. Please give me a thumbs up if I'm clearly audible. If I'm clearly audible. Am I clearly audible? Hello, 1, 2, 3, mic testing. So we'll begin the session once I get confirmation. Okay, so we are live. So I think I'm clearly audible. So our first question is. Okay. So let's define inquest. So students, what is the inquest? Definition of inquest is an inquiry into the cause of suspicious death or sudden death or unnatural death. What are the types? Police inquest, magistrate inquest, which are these two are practiced in India. What is coroner's inquest and medical examiner's inquest? Do I have to do some settings or something? There's something wrong with this mic. I've set the mic properly. Oh my god, oh my god, there aren't a lot of disturbance. Okay, 1, 2, 3, I think I'm audible. So let's. Okay, I think we are live and I'm audible perfectly. So let's begin. So what is the inquest? Define inquest. So how will you define inquest? An inquest is an inquiry into the cause of death. So an inquest is an inquiry into the cause of death. Why there is an inquiry? Because this death might be unnatural death, or maybe a suspicious death, maybe a crime or homicide. Crime is nothing but homicide, or there might be any suicide. So an inquiry into the cause of death is called an inquest. What are the types of inquest? There are Four types, two are followed in India and two are not followed in India, they are followed outside. Okay, so the one is police inquest and magistrate inquest. These two are practiced in India, and coroner's inquest and medical examiner's inquest. These two are not practiced in India, they are practiced in foreign, like in USA. Okay, coroner's inquest and medical examiner's inquest. Okay, so let's first discuss about police inquest. What is the police inquest? Okay, so what is a police inquest? Police inquest is it is the inquest conducted by the police officer in charge of a police station. Okay, he should be in charge of the police station, and this police officer, if he is carrying out the inquest, it is called the police inquest. Okay, so how will the police carry out? So first, on receiving information about the suspicious or unnatural death, the police officer he will first inform to the magistrate. First, he will inform to the magistrate and he will visit the scene of crime and conduct panchnama. Panchnama is nothing but the inquest. So, in the presence of two panchas in the sense two respectable persons of that locality, in the presence of these two respectable persons called panchas, in presence of them, the police officer will conduct the panchnama. He will make the inquest. Okay, an inquest report is prepared, which is signed by the police officer and the panchas. Who is the panchas? Panchas is the respectable person of the society. Okay, it mentions about the apparent cause of death. So, what is the apparent cause of death? We don't know the actual, because actual cause will be known after the autopsy. Whatever is heard from the people around, that will be noted down. Okay, that is the apparent cause of death, not the actual cause. Okay, injuries is present and circumstances leading to death. Okay, whatever injuries are there. So first, the police officer will receive the information about the suspicious death. Then he will first inform to the magistrate. Then he will visit to the scene of crime. Then he will visit to the scene of crime. Then he will visit to the scene of crime. First, what will happen? First, the police officer who is in charge of the police station will receive the news about the unnatural or suspicious death. He will inform to the magistrate. After informing to the magistrate, then he will visit the scene of crime. He will visit the scene of crime. The police officer will conduct an inquiry and he will form a panchnama. Panchnama is nothing but inquest. Okay, he will prepare report. So if any foul play is suspected, he will request the doctor to perform the autopsy. The body will be taken to the autopsy lab. But if there is no foul play, the body will be handed over to the relatives. Okay. So if there is any foul play, if foul play is there, then autopsy should be done. If no foul play, then the body is handed over to the relatives. Okay, so this is how the panchnama is inquest is performed. Okay, what are the details taken in the inquest report? The first detail is the name of the victim. Okay, name, then age, then what is the gender, address, occupation, marital status. Okay, then date, time, place where the inquest is conducted. Okay, the time of starting the inquest commencement and the time of completion of inquest. The body, who identified the body, the spot where the corpse was found, where the body was found, whether it was home, whether it was well, whether it was roadside, whether in the jungle, forest, whatever, in the lake, whatever. Okay, what is the place, the spot where the corpse was found? State of corpse, whether it is fresh, decomposed body, what is the posture of the body, if there any injuries is present, like stab wounds are there, or if any accident wounds are there. So whatever wounds are there, if injuries is present, and what is the apparent cause of death. These things will be there. One second.
Okay, so let's begin. Continue with this. Okay, so we have discussed about how an inquest is conducted by the police. First, the police, as soon as he hears the news, what he has to do, he has to inform the magistrate, and he will visit the scene of crime. He will prepare a report called the Panchnama or inquest. Okay, this report will consist of the name, age, sex, address, occupation, and marital status of the victim, date, time, place where the inquest is conducted, time of commencement and time of completion of inquest. Okay, when he started the inquest and when what time the inquest is completed. The body identified by whom, spot where the corpse was found, whether it was a house, whether it was a well, whether it was a road, whether it was pond, lake, whatever. Okay, the other is state of corpse, whether the corpse is fresh or decomposed. Posture of the body. Okay. Injuries, if present an apparent cause of injuries. What is the apparent cause? Whether it is accident, strangulation, hanging, whatever. Okay. So these things are there. Fine. Next. Fine. So okay, next what is that? Magistrate inquest. Okay, magistrate inquest according to BNSS means Bharatiya Nyaya Samhita. Okay, Samiti. So this 196 section. Okay, section 196. Bharatiya Nyaya Samiti section 196. Defines magistrate inquest. What is a magistrate inquest? It is an inquest conducted by a district magistrate or subdivisional magistrate or magistrate of the first class or rank or executive magistrate such as collector, deputy collector or tehsildar. Okay. Section BNSS 196 deals with the magistrate's inquest. It is practiced throughout India. It is not held routinely but only on special circumstances. What are the special circumstances? When magistrate inquest is performed, when when the death is within the police custody, like lockup deaths, deaths in police custody, deaths during police interrogation, when the police was asking the truth with the victim, with the accused, then the death is taking place because of excessive beating or excessive things. Okay, death in prison, death due to police firing, death in a psychiatric hospital, dowry death like suicide or death of a woman within 7 years of marriage, it is called dowry death. And the death of a woman is within 7 years of marriage. Exhumation death, exhumation cases, when such type of inquiry is to be held, the magistrate should inform the relatives, that is parents, children, brothers, sister and spouse of the deceased, and allow them to remain present at the inquiry. Purpose. The main intention behind the magistrate inquest is to ensure that no person is unjustly deprived of his or her liberty and his or her rights as citizens of the nation. No person who is deprived of his or her liberty can die as a result of neglect or brutality of people who are in charge of him or her. In case of a buried body, there is no doubt with regard to the identity, cause of death, or manner of death. The death is not a dowry death. That death is not a dowry death. There should be no death because of the dowry. Okay. What is coroner's inquest? Coroner's inquest is a graduate in law. Who is a coroner, first of all? Coroner is a graduate in law with at least 5 years of legal practice. He is appointed by the government. What he does, he conducts inquests with the help of jury. Who is a jury? Group of respectable person of the society. Because this is followed outside of India. Okay. What is the purpose of conducting magistrate inquest? Because no person is unjustly deprived of his or her liberty and his or her rights as citizen of the nation. Okay, no person who is deprived of his or her liberty can die as a result of neglect or brutality of the people who are in charge of him or her. In case of a buried body, there is no doubt with regard to the identity, cause of death, or number of death. Death or manner of death. Okay, the death is not a dowry death identified. Okay, so coroner's inquest. Coroner is a graduate in law with at least 5 years of legal practice. He is appointed by the government. He conducts inquest with the help of a jury. Jury means respectable person of the society, like we have panchas. In foreign they have jury. Coroner conducts inquest on any suspicious death or unnatural death or death in prison, death in custody, death in a psychiatric hospital. If necessary, can order for autopsy and exhumation. If it is looking like any suspicion, then the coroner will order for autopsy and or exhumation. Coroner's court is a court of inquiry. He or she can call witness to give evidence. Okay, he can call witness to give the evidence. It cannot conduct trial and cannot award punishment. Coroner's inquest was practiced in Bombay and Calcutta. Now it is not practiced in India. Okay, it is practiced in England, Australia, New Zealand, Sri Lanka, USA. Okay, what is medical examiners in system? It is practiced in the USA. Forensic pathologist is appointed as medical examiner by the government. So medical examiners inquest, this is also not practiced in India. It is practiced in USA. It is practiced in USA, guys. Where it is practiced? It is practiced in USA. Okay, so the forensic pathologist, he is appointed as medical examiner by the government. Okay, so here medical examiner visits the scene of crime and conducts inquiry into the cause of death. He or she examines the dead body and collects evidence. He or she does not have any judicial powers. Okay, it is superior to other types of inquest because doctor has both first-hand knowledge of the scene of crime, dead body, its state, its posture, etc. So he has both medical knowledge and legal knowledge, forensic knowledge. So he is the expert, right? So he or she can collect trace evidence such as hair, blood stains, seminal stains, etc. And he or she can correlate it with the autopsy findings. So that's why the medical examiner's inquest is superior than any other inquest. Okay, so this is the our LEQ. Okay, so what is medical examiner's inquest? It is practiced in USA. It is not practiced in India. It is not practiced in India. It is not practiced in India. It is practiced in USA. It is not practiced in India. It is practiced in USA. Fine. So forensic pathologist is appointed as medical examiner by the government. medical examiner, he will visit the scene of crime and he will conduct the inquiry into the cause of death. He or she examines the dead body and it collects the evidences. 1 second, I will adjust the mic because it's capturing all the unwanted sounds. This should work. I guess this should work. He or she can collect trace evidences such as hair, blood, stains, and minor stains. Okay? So guys, if you're liking the session so far, please share the video so that there will be more energy and enthusiasm, more questions we can do. Okay, at the end of the chapter, we will discuss the questions. So he or she can collect trace evidences such as hair, blood stains, some minor stains, etc. And he or she can correlate with the autopsy findings. Courts in India. So now let's discuss about the procedure of recording evidence in a court of law. Procedure of recording evidence in court of law. So the question, it can come as a small answer question. Describe the procedure of recording evidence in a court of law. So procedure of trials in court, recording of evidence. So recording of evidence, okay. What is the procedure? First, the witness is called to the court through summons, okay. Through summons. Summon, what is the summon? Summon is the important question, guys. What is the summon? Summon or subpoena? What is the summon or subpoena? What is a summon or subpoena? We'll discuss in detail further. But subpoena or summon is a document compelling a witness to attend the court of law on a particular date, time, and place to give evidence under penalty. Sub means under, pena means penalty. Okay, subpoena. So it is a document compelling a witness to attend the court of law on a particular day, time, and place to give evidence under penalty. What is the type of subpoena? There are different types like civil subpoena. It is issued in a civil case. Criminal subpoena issued in a criminal case. Trial subpoena requires a witness to appear and testify at a trial. Subpoena ad testification. Testicandum requires a person to testify in court on at a deposition. Subpoena duces tecum requires a person to produce documents. Civil subpoena issued in civil cases. Criminal subpoena issued in criminal cases. Okay, summons or subpoena. So BNS 63 to 71 deals with the summons. Summon is a document compelling a witness to attend the court of law on a particular day, time, and place to give evidence under penalty. Sum means under, P means penalty. So magistrate sends a summon. Magistrate, what he does, he sends a summon with a sign, which is signed and stamped to the witness through police or government servant. or he can send in encrypted or any other form of electronic communication and shall bear the image of the seal of the court. Two Xerox copies are issued. The witness signs on them and keeps one copy with him or her, and the other copy is returned. If a witness fails to attend the civil cases, he or she is liable to pay the damage. If a witness fails to attend the criminal case, he or she gets an arrest warrant. Okay, a witness is excused from attending the court if he or she has a valid reason. The reason should be valid. If a witness is summoned by two courts on the same day, criminal court has priority over the civil court and the higher court over the lower court. If he or she should inform the other court about the same. Summons to medical professionals to testify in court regarding post-mortem report, injury certificate. Summons to medical professional by sent to testify in court regarding post-mortem report, injury certificate, age certificate, assault, sexual offences, etc. Legal consequences of ignoring the summons. Court may issue bailable or non-bailable warrant. Okay, bailable or non-bailable warrant. Okay, what is a summon or subpoena? According to sections BNSS 63 to 71 deals with summons. It is a document compelling a witness to attend the court of law on a particular day, time and place to give evidence under penalty. Types of subpoena: civil subpoena issued in civil case, criminal subpoena issued in criminal case, trial subpoena requires a witness to appear and testify at the trial. Subpoena and testification requires a person to testify in court or at a deposition. Subpoena duces tecum requires a person to produce documents, records, or evidences. Okay, why I'm speaking so loudly? Already I am using a mic. Each type serves a special legal purpose depending on the case. Okay, so what is the summon or subpoena? It is a document compelling witness to attend the court of law on a particular day, time, and place to give evidence under penalty. To give evidence under penalty. Okay. So what are the types of subpoena or summon? My screen visible properly? Magistrate sends a summon which is signed and stamped to the witness through police or government servant, or he can send in encrypted or any other form of electronic communication and shall bear the image of the seal of the court. Okay. So what is the summon? So what is the summon, guys? We are discussing forensic medicine. In forensic medicine, we are dealing with the chapter legal procedures. So what is a summon or subpoena? It is a document compelling witness to attend court of law on a particular day, time and place to give evidence under penalty. Types of subpoena: civil subpoena, pena means penalty, sub means under penalty. Okay. Actually, uh, to the person who is called for summon is given a money. That money is called conduct money. Conduct money is the payment given to a witness to cover the expenses for attending court or legal proceedings. What is the purpose? To cover the travel, accommodation, other necessary expenses. To cover travel, accommodation, other necessary expenses incurred by the witness. It ensures that attending court does not cause undue financial burden to the witness. What is the legal requirement? Subpoena or summons must be accompanied by conduct money. Subpoena or summons must be accompanied by conduct money to be legally enforceable. If adequate conduct money is not provided, the witness may have grounds to refuse attendance. What is the amount? The amount varies depending on jurisdiction, distance, and type of witness, ordinary or expert. Expert witness. So one point I want to say, what I discovered is it is sometimes we get so much of tired and we just want to eat, but that is not the food hunger. It is the liquid hunger, water hunger. Not when you are not having adequate amount of water, you feel hungry. But actually, it is not the hunger of for food. It is the hunger for water. Okay, because your water is very important. It will also help in reducing your hunger and getting rid of obesity. Okay, so have at least 3 liters of water a day. Okay, so now moving further, moving further, we are discussing about the procedure of recording in evidence. Okay, so what I said first, the witness has to take the oath. So witness is called to the court through summons. Through summons, the witness is called to the court. So administration of oath or affirmation. Okay, chief examination done by lawyer of same party. Cross examination done by lawyer of opposite party. Re-examination done by lawyer of same party. Okay. So first, the witness who is called to the court through summon, administration of oath or affirmation, chief examination done by lawyer of same party, cross-examination done by lawyer of opposite party, re-examination done by lawyer of same party. So the re-examination by the same party, cross-examination by opposite party, chief examination done by lawyer of same party, chief examination and re-examination by same party. So lawyer for the opposite party, witness lawyer for the same party. Okay, cross-examination question by the lawyer of opposite party. Leading questions are allowed. Only leading questions are allowed, not the stupid questions. Only leading questions are allowed. Okay, for cross-examination. Chief examination, witness in witness box is there. Okay, questions of lawyer by the same party. Re-examination, witness in witness box and question by the lawyer of same party. Evidence of a witness is recorded under oath in the witness box. Okay, evidence of a witness is recorded under oath in the witness box. The oath is as follows: I do swear in the name of God that what shall I state to the court shall be the truth, the whole truth and nothing but the truth. If the witness is an atheist who is not believer in God, he or she solemnly affirms the above sentence. Okay, if the witness is atheist who do not follow any religion, then the oath should say that I swear in the name of God. In the name of God, what shall I state to the court shall be the truth, the whole truth, and nothing but the truth. Child below 12 years of age is not required to take oath. After administration of oath, if a witness does not speak the truth, he or she is liable to be prosecuted for perjury. Okay, he or she is prosecuted for perjury. Perjury. Okay, examination in chief. This is the first examination of the witness. So, if the witness is an atheist, not believer in God, he or she solemnly affirms the above statement. Okay, so if he is not a believer in God, so the statement I do swear in the name of God is replaced with I solemnly affirm the above statement that I shall state to the court to be the truth, the whole truth, and nothing but the truth. Okay, if the person is less than 12 years, then he is not required to take oath. What is examination in chief? This is the first examination of the witness, consists of question by the lawyer of the same party who has called him or her. The main objective is to elicit all the relevant facts and conclusions. Okay, relevant facts and conclusions. Relevant facts and conclusions. Okay. So this is the first examination of the witness, which is examination in chief. Okay, what is the summon or subpoena? These are document which is compelling a witness to attend the court of law on a particular day, time, and place to give evidence under penalty. The money given to the witness to attend the court is known as conduct money. What is the purpose to give the money? The payment is done to the witness to cover their expenses for attending court or legal procedures. It ensures attending court does not cause undue financial burden to the witness. Okay, now talking about the important topic, that is procedure of recording evidence in a court of law. We have seen first the witness is called into the witness box and he is asked to take the oath. The oath is as follows: I do swear in the name of God that what I shall state to the court shall be the truth, the whole truth, and nothing but the truth. If the witness is an atheist, not believer in God, he or she solemnly affirms the above statement. The above sentence, instead of God, he shall use solemnly affirms. Okay. Child below 12 years of age do not require to take the oath. After administration of oath, if a witness does not speak the truth, he or she is liable to prosecuted for perjury. Perjury is a serious offense in which after taking the oath also the person is saying lie. So he will be given the punishment for that. So first there is examination in chief by the